may be seated.
SJC-13123, Commonwealth v. Leon G. Dufresne.
Okay, Attorney O'Brien,
Yes, good morning.
good morning.
Thank
may
you, Your
begin.
Honor. Should I begin?
Yes, please. Thank you.
Thank you. Jennifer O'Brien for the defendant, Leon Dufresne.
Talk a little louder. Could you talk a little louder?
Yes, absolutely. I'd like to just recognize trial counsel Alexei Tomasco, who made this argument, preserved it below, as well as all the amicus briefs filed in this case. I think the question in this case that the court is interested in is whether or under what circumstance a defendant is entitled to the assistance of counsel in connection with the 209A proceeding, and whether that lack of counsel when an order issued infringes on his constitutional right to due process or the right to assistance of counsel. Now, we start with the premise that a 209A is a civil judicial order that, when violated, automatically turns criminal. The defendant, an indigent defendant rather, is not afforded an attorney at the initial hearing. And I don't mean the ex parte hearing. I'm not arguing, just so the court is aware, that an attorney should be appointed at the ex parte hearing. I understand the emergency nature of these 209As in certain cases, and I think it would be unethical for an attorney to represent a defendant at an ex parte hearing when he's never met that defendant, obviously. So I'm talking about the hearing that occurs 10 days after the initial ex parte hearing. And in that situation, the defendant is usually presented with some sort of underlying criminal conduct. Not always, but there the plaintiff is alleging that there is an imminent fear of bodily harm. And in order to allege that, it usually arises from some sort of criminal conduct, whether that be a threat of violence or actual physical violence. So the defendant is placed in a position where he has no right to counsel. He's not an attorney. And if he says anything, obviously, he could incriminate himself in an underlying criminal case, whether or not there is an underlying criminal case. It usually involves criminal behavior. And there are fundamental, in addition to the criminal side of it, there are fundamental critical human rights at stake. The termination or temporary termination of parental rights or custody, child contact. The defendant may have to vacate his residence. He has to turn over firearms. The court can order the removal of animals from the defendant's custody, order him to attend the certified batterers program.
Counsel, can I ask you a quick question on this?
Absolutely.
When you make this argument, you talk a lot about the consequences that could happen from not being afforded the right to counsel. I'd like to focus more on the proceeding, though, because at the proceeding, where the plaintiff, who arguably now has an ex parte order, is now seeking an extension of that order. Are you suggesting that the defendant needs the right to counsel in order to effectively participate in that hearing?
I am arguing that, yes. The answer to that question is yes. But if this court rules that an attorney is not automatically appointed, then I am arguing that since it is a judicial order, a civil order, it should be enforced civilly. That's another option, since it is a judicial civil order.
Don't we have other civil proceedings that are enforced through law enforcement? No trespass orders?
Yes, but they're not judicial orders. I mean, a trespass order can be one party to another just saying, you're no longer welcome in my house. It can be a sign that's posted outside, and that turns criminal. Absolutely, violation of that is a criminal. But here, I think it's a unique statute because it's a judicial civil order, and normally judicial civil orders are enforced by the judiciary, and they can become criminal, absolutely, and certainly even enforcing a judicial civil order, incarceration is appropriate where the judge deems that it is.
So if there's the equivalent of a 209A order in the probate and family court, would the right to counsel apply in the probate and family court as well?
It should. I don't think it would matter where the 209A is issued. I think particularly in cases where there's child custody, and I understand they're not ordered in a divorce proceeding, but the 209A is unique in that if the plaintiff asks for no contact whatsoever, oftentimes it is granted. And I know the Commonwealth has argued, well, these are modifiable. And they are, certainly, but the defendant who is indigent, who can't afford an attorney at the first instance, is certainly not in a position to either hire an attorney for an appeal or hire an attorney to go to the probate court. A lot of these stay in effect for the entire year because the defendant, indigent defendant, just doesn't know what to do. And I would point out that the burden of proof initially with these is the plaintiff must prove by a preponderance of the evidence. In order to go back and modify these, the burden is raised for any defendant. It has to be by clear and convincing evidence that there's been a change in circumstance that no longer warrants the order.
For a modification, I know we said that for a termination of the order, but for a modification, you're saying that the standard is clear and convincing evidence?
Yes, that's my understanding, yes. The clear and convincing for a 209A for the defendant to come and change the 209A. Yes, so where there's two different standards, the defendant obviously is in an uphill battle in these.
George, are you done or?
Thank you, Justice Scott.
Can I ask you to address the amicus brief? Doesn't that idea provide you all the necessary protections and avoids what would be almost an astronomical cost and operational problem with getting counsel in all these cases? I assume the state's gonna have to pay for all those counsels. So wouldn't the proposal that appears in the amicus brief provide you the necessary protection without that cost?
I apologize, which amicus brief are you?
I think it's the CPCS amicus brief, which talks about use immunity.
Oh, yes. Yes, that's another option, which these amicus briefs are great because they've all suggested
But
different
would that
ways around
option-
it. Yes.
Would that option provide you, is there anything that option wouldn't provide you with that you're concerned about?
Well, that would certainly address the problem with the Fifth Amendment and speaking and incriminating yourself, because in order to defend yourself for the 209A, you might incriminate yourself on any open or not yet filed criminal procedure. But I don't know, proceeding rather, I don't know that it would address all the other problems as far as child custody and Second Amendment removal of firearms problems.
Well, your first argument, if I have it right, is that it's, as you were just, I think, referencing, the implications of the order are so significant that there should be a right to counsel. And I think the Women's Bar Association, the BBA, pick up on that as well. But isn't this different than when we've had right to counsel before on the civil side, where the state's not involved as a party when the judge is deciding whether or not a 209A order should issue? It's not like, for instance, a termination of parental rights.
Well,
Does that matter?
I don't know that the state necessarily has to be a party. I think there is state action for certain, whether or not the state is a party.
Well, I guess I should ask it a different way. Do we have any circumstances where we have ever said that there's a right to counsel, or under the United States Constitution has been interpreted as a right to counsel in a civil case where the state's not a party?
No, not a Sixth Amendment right to counsel. Here, certainly the victim witness advocate, while they do not represent the plaintiffs in these cases, they are they are part of the Commonwealth, part of the prosecution in this case law that supports that they're part of the prosecution.
But they're not part of the petitions
They're
on
not.
a grand, they're not part of the petitions on a grand scale. You might have a victim witness advocate participate if there's a corresponding criminal case that comes out of the underlying conduct. But the vast majority of people that come in to petition for 209A don't get the assistance of a victim witness advocate.
Well, the state enforces the order. So I would say that the state becomes the enforcer of any of these orders. I mean, there is, in my, I believe, adoption of Megan, that was a private adoption, guardianship of BV, that's a petition to guardian of a minor. These attorneys were appointed in these cases, or it was found that attorneys were necessary rather in these cases where the state was not a party. But I would argue that at least the prosecution participates in I mean, I practice in Lowell District Court regularly, and in every 209A, there is a victim witness advocate there who helps the plaintiff with the paperwork and was present in court in support of them.
When they come in like at 4:20 in the afternoon, are they still there then?
If they're available, yes, it's my understanding the clerk will call the victim witness advocate who will come and help them fill out the
Well,
paperwork.
I have one other question, and that's related to I understand you're arguing the harm is ultimately in the fact that he could possibly go to jail or go to prison for violating the restraining order. In this particular case, what ills flowed, other than the mere issuance of the order, not the mere issuance, but what did he say something that was used against him later? What came out in the original proceeding that caused him a problem later, other than the issuance of the order?
Nothing was introduced as far as, in evidence that the defendant might have said at a hearing. So he was present at the hearing. I didn't represent him at the hearing, but there was nothing used in his trial against him, if that's your question. He was ordered automatically to vacate a housing unit where he lived. So he immediately had to leave.
Right. Now these provisions that you're referencing were put in by the legislature, correct?
Which provisions?
Well, the ones in the 209A law, like get out of the house,
Yes.
get rid of your guns, those
Yes.
things. The legislature put them in.
Yes.
Did the legislature add any other protections before that, or what did they do to protect somebody from having that done irrationally?
Not much, Your Honor. I think.
And why do you think that was?
Well, because obviously the state interest or the Commonwealth's interest is in protecting a plaintiff who is
Right.
being abused. So,
Right.
and I recognize that, and I understand that is a huge interest. But they essentially say you can come back in 10 days and fight
Do
it.
you know whether the domestic homicide rate has gone down in Massachusetts since we've had these orders?
I assume it
Or gone
has,
up?
Your Honor. I don't know. I don't know the answer to that, but I'm assuming that they are effective, and I'm certainly not arguing that they're not effective. They absolutely are. But in this first instance, I mean, it's issued ex parte, and the police officer will go and serve this order upon someone. I had an instance where the defendant was intoxicated, on a 2-day bender, and they give him the order. He went back to get his property and he was arrested. There might be an individual who's incompetent, and this is and the defendant and this is back to the argument of it being civil, at least in the first instance, that the person might not understand that, and the judge wouldn't recognize that until the person came before him. There's obviously, if the person commits an independent criminal act, threatening someone, hitting someone, and anything like that, they're going to be charged criminally. So I think that the problem here, at least from the defendant's perspective, is that it's a civil judgment that turns criminal automatically without the right to an attorney. And
Yeah,
yes,
follow up on that if I could, please. So when we look at the Matthew versus Eldridge factors in determining due process, and we're evaluating the risk of erroneous deprivation, do we consider that as it relates to the particular hearing that's taking place, whether or not the 209A order should be extended from the ex parte or from the initial? Or are we taking that Matthews factor down the road to a proceeding that hasn't occurred yet?
well, I think you can look at it. I mean, obviously, you can look at it in both instances because one informs the other. But in the initial hearing, certainly weighing those factors. I mean, we understand obviously the Commonwealth's interest, obviously, in protecting individuals who are victims of abuse. But I think if you look at the initial hearing with the burdens of proof that the defendant really, it takes a huge risk by saying anything in defending these orders. The fact that they're not lawyers, they're not used to cross-examining someone. I think that it comes on the side of appointing counsel. And I know, obviously, and I don't blame the court, that this is obviously an issue for the court, is the cost, right, of litigating or appointing all of these attorneys for defendants in 209A cases. But I mean, if you look at it, if there's no attorney that is appointed in an ex parte case, obviously because they've never met a defendant, so they can't begin to represent someone they've never met. A lot of these plaintiffs, some of them do not come back after the initial order is entered. So for those people, an attorney would not have to be represented.
Well,
Another thing.
that's a good question, because one thing I noticed when I was in practice years ago, and we had divorces, the introduction of attorneys often drag things out and make things worse.
Mm.
Is that, you're saying she doesn't come back the second time. Now if everybody's getting a lawyer, maybe she will. I mean, could it not make this worse
Well,
in terms
if,
of the litigation?
I understand, and it depends on the attorney as far as
does.
dragging things out. I completely agree with you. If the defendant is appointed an attorney, I'm talking about the cost analysis. I don't think affording the defendant an attorney would make it more or less likely for the plaintiff to come back. But if the plaintiff was afforded an attorney, yes, it might make them more likely to come back, which if they need the order, I think that's a good thing, obviously.
Yeah,
A lot of
in
these cases.
In a
Yes.
better world, we'd have a lawyer in housing and divorce. We have huge numbers of important legal proceedings that are now being done pro se. But
Yes, I understand that a lot of people.
is 209A different from the fact that you can lose your house or your marriage can end without us requiring representation? I mean, you know, you're crossing that big civil criminal divide we have here.
Well, I understand that, but the 209A doesn't just deal with housing. It deals with so many rights. It deals with constitutional rights. It deals with, surrendering firearms, Second Amendment rights. It deals with, custody and contact with your children. One day without being able to speak to your children, it's a big deal to people. A lot of these cases, they arise because there is an underlying criminal case. So the defendant is charged with, say, assault and battery, and the victim is there and getting a 209A at the same time. And essentially what is happening in the courts is that the judge will essentially tell a court-appointed attorney, okay, step back, step aside for the 209A, tell the defendant, you don't have a right to an attorney, you have a right to an attorney, this attorney is not representing you, do you want to speak? And then the court-appointed attorney steps back in for the arraignment. So a lot of these cases, you wouldn't necessarily need an additional court-appointed attorney. It really doesn't make sense for this attorney to have to step back for the 209A and then come back in for the underlying arraignment, but that's essentially what happens. I think this 209A.
Counsel,
Yes.
counsel, I'm sorry, it appears your time has expired, so if there are no other questions.
I have one other question, and that is, what are other jurisdictions and the federal government doing in this area?
I think one of the amicus briefs addressed that. I think New York State is the only state that allows representation, court-appointed indigents by right. I think
For the
there's
initial,
another
the
state with
initial
juveniles.
request,
I'm sorry.
for the initial request for the order, for the emergency order.
Well, obviously, I don't believe it's at an ex parte stage.
Okay, but so then for the initial, the second one, I mean, after
Yes,
the.
exactly. And there's another jurisdiction who allows them for juveniles.
And they
And
court
again,
appoint them.
yes,
And do they have a procedure to determine indigence?
I don't know that. I'm assuming it's the same procedure that courts use in whatever state.
Okay, thank you. I'm
thank you.
content. Thank you. Thank you,
Yeah.
Chief.
Okay, Attorney Tretyakov.
Good morning, Madam Chief Justice. May it please the court, Konstantin Tretyakov, Assistant District Attorney for the Middlesex County District Attorney's Office representing the Commonwealth. There are three issues on this appeal. Two of them concern the trial judge's rulings on the defendant's motion for a mistrial and limiting the scope of the victim's testimony. The third issue concerns the propriety of the motion judge's ruling, who also was the trial judge, on the defendant's pretrial motion to dismiss on constitutional grounds. With the permission of the court, I will focus on the third issue, and then if the court has any questions or if there is time left, I address the remaining two. With respect to the right to counsel at 209A hearings, it could conceivably stem from three grounds. One is the statutory ground that the defendant mentions in his brief, the statute about sex offenders, the statute about involuntary civil commitment. That is not available to the defendant. None of those statutes would apply by analogy to the defendant's situation, so that reliance is misplaced. The second basis is the Sixth Amendment that also in this case avails the defendant of nothing, because this court has repeatedly declared that the Sixth Amendment rights are only available at the critical stages of prosecution. And as this court also explained, prosecution is a term of art and it only refers to events or actions after arraignment or after indictment. It is axiomatic that the 209A hearing, it is a civil proceeding between two private parties. There has been no indictment, there has been no arraignment for a violation of a restraining order at that stage, because the restraining order is just being issued or may be issued at that hearing, which does not always happen. So the Sixth Amendment right would not be applicable to the defendant as well. And then finally, the due process. The guarantees of due process can command that the defendant be afforded the right to counsel. And under the due process guarantees, this court has sometimes found the defendants the right to counsel for the defendants in civil proceedings between two private parties, and sometimes it hasn't. For example, in the Burchell case from 2009, this court unanimously ruled that in the civil contempt proceeding, the defendant, as a matter of due process, can hire his own private counsel, but there is no right to counsel at the expense of the Commonwealth. In other contexts, for example, in the termination of parental rights, this court has found the right to counsel for the defendants, but I think for the parents, who are facing the termination of parental rights. But I think it is important to keep in mind and to recognize the context in which that pronouncement was made in those termination of parental rights and adoption proceedings, because my understanding of the Massachusetts law is that once the consent of a biological parent, that requirement has been dispensed upon, the parental rights are terminated and the child finds a new family, that becomes irreversible. There is no way to restore parental rights once they have been terminated in Massachusetts. That is the end of the line, so to speak. And in that context, this court recognized the terrible loss that the possibility of the loss, the magnitude of the loss that a biological parent is facing.
But
And they
I
recognize
think
that when
the issue is the intersection with the intersection of the civil and criminal proceedings here, that one can lead to the other, and even the actual factual allegations can result in both, the 209A order and the, assault and battery or the various criminal actions. And, I think the point is that if the defendant's up there talking, he may be, creating problems for his criminal case. So how do you address that?
Yes, Your Honor. I think it is important to keep in mind that I understand the interest in the court in the global implications of this matter, but if the court looks at this case itself, the order, actually, there was no issue of the custody of the children. There was no issue of termination of, or there was no issue of visitation. There were none of these issues.
And the defendant didn't testify. Did the defendant in the 209A proceeding, he represented himself. Did he put on evidence? I mean, how did that go?
I do not know, Your Honor. I even do not know. There is no record whether the defendant even asked for the assistance of counsel during the 209A hearing.
I understand he didn't ask for it, but he may not understand that's why he may need counsel.
Pardon me, Your
I
Honor.
apologize to Mask again. The issue I think raised, particularly by the amicus, the interesting issue is, are you subverting your criminal case in the 209A proceeding? We may not have to deal with that based on, I think, what opposing counsel just said, which is there wasn't anything in the record. Is that right? That there's no issue that he said anything in the 209A proceeding that could hurt him in the criminal proceeding? Is that, or we just don't know what he did?
I believe that none of that was ever used at trial, if there was anything, but the record is completely silent. There is simply no record to conclude one way or the other. We do not have the transcript of the 209A proceeding. There is no indication that the defendant actually asked the court for the assistance of counsel.
But counsel, considering the fact that the person on the other end of this has a chance that they could violate something they don't understand in a way they don't understand, almost, accidentally even, and could end up in jail. What is the harm in giving an attorney?
Your Honor, I would respectfully frame the issue as to not what is the harm of giving an attorney, but whether the defendant is constitutionally entitled to the right to counsel. And that, of course, requires the application of the Turner, Lassiter, and Eldridge line of cases here.
But didn't we just do something? Well, we didn't. Never mind. Go ahead.
My apologies, Your Honor.
Oh,
Thank
no,
you.
you go ahead. I was wrong.
So, and the three factors that these cases all command to consider, as this court has recently acknowledged in the Grulon case, is the nature of the affected private interest, the comparative risk of erroneous deprivation of those interests with alternative or substitute procedural safeguards, and the countervailing interests at stake. And here,
going back to the question I asked for Ms. O'Brien, as it relates to the second factor, the
Yes,
risk
Your Honor.
of erroneous deprivation of that interest, and what substitute proceedings might provide for safeguards, has that provision of Matthews versus Eldridge ever been interpreted to analyze not the actual proceeding in question, but the implications of that proceeding for another proceeding?
not that I'm aware of, no, Your Honor. I think my reading of the Turner case and my reading of the Grulon case that applied the Turner framework was that both the Supreme Court of the United States and this court were focused on the procedure at hand. And here, I think there are ample procedural safeguards that ensure that both plaintiffs and the defendants have equal access to the abuse prevention order proceedings, and that, in response to Justice Seifer's question, they understand the results of those orders. For example, there is the requirement of the notice to the defendant. The defendant has the opportunity to respond. There must be an explicit finding of the fact that there is a likelihood, there is abuse or substantial likelihood of abuse for an order to issue. So, and all these factors, the court cited approvingly in Commonwealth against Grulon, but the statute and the applicable guidelines for the judicial practice in abuse prevention order proceedings that were cited by this court approvingly multiple times, they also provide additional procedural safeguards for the defendants. The burden of proof lies solely with the victim. The defendant doesn't have to prove a thing. The burden of proof is the preponderance of the evidence. If the order is issued after the hearing,
How
which
do
the-
we decide, counsel, whether these procedures are enough to satisfy due process? Yeah,
Your Hon-
I understand there are procedures.
Yes, Your Honor.
Is it enough?
Yes, Your Honor, I believe so because.
No, but what's the measure? Of course you believe so. That's what side you're arguing. What is the metric that I should use from a legal perspective to figure out whether or not the procedural safeguards are enough to guarantee due process?
Yes, Your Honor. I think there are two helpful considerations here. One, as this court recognized most recently, I believe in the Caruso case, the overarching purpose of the 209A chapter and all these proceedings is the safety of the plaintiff. That is, I think, the fundamental concern through the lens of which all the defendants' arguments and all the Commonwealth's arguments about due process need to be evaluated. And second of all,
That can't be right.
Yeah, that can't be right.
That
I
can't be
mean,
right, because you've got the defendant's interests of being wrongfully accused and losing, all the, including the constitutional rights we were just talking about. So it's the Matthews versus Eldridge balancing test, but it's both sides. It's not just the plaintiff.
Your Honor, I would then, in response to Justice Wentland's question, again, it is admittedly hard to pinpoint the precise measure as if there was a scale, but I do think that this court's jurisprudence, especially the Grulon case, where the court cited approvingly certain procedural safeguards put in place in a child support proceedings, all of which, again, are present in the abuse prevention order proceedings, and the additional procedural safeguards that the guidelines have, they all, I think, counsel towards the conclusion that those additional procedural safeguards, along with the two other factors under the Turner line of cases, they all support the conclusion that there is no due process right for the assistance of counsel. Take the nature of the affected interest, for example. In this case, what were the interests that were actually affected by the order?
Right. I know in this case, maybe it's not such a, you'll say the interests were not that large, but in other cases, there is the custody, not the termination of parental rights, but certainly custody determinations. There's, of course, the Second Amendment rights. And what if those were implicated?
Your Honor, with respect to the Second Amendment rights, my understanding is that, at least at the federal jurisprudence level, if there is a specific constitutional provision available to the defendant that specifically protects those interests, he or she cannot rely on the generalized notion of due process. So I'm not sure how that would interplay, but even putting that issue aside, I think it is important to underscore that all these abridgments, all these limitations on the defendant's rights are temporary, because by virtue of
So you have a child and temporarily for a year, you don't get to see, touch, hear, interact with that child.
Your Honor,
You're saying that's not a due process violation without counsel?
Your Honor, well, again, this is certainly not the case here,
Right,
but
I'm asking about a different case, the next case, the hypothetical, where I have a child and I have a 209A issued against me because I don't have counsel and I said some things. And you're saying that these other safeguards are enough. And I'm wondering, how do you measure that?
Your Honor, in that hypothetical case, the defendant can petition the court that issued the order at any time. And if that defendant presents the proof by either preponderance of the evidence or clear and convincing evidence standard, that order can be amended or it can be terminated by the court.
Right,
That
and I guess the question for me is, yeah, I understand that there's these burdens of proof, and understand that you can modify the order either by clear and convincing or preponderance. One should figure out which one it is. Why don't I get counsel for that? I want my kid back.
Your Honor, again, in a similar, well, it's not a perfect analogy, but in the Burchell case, this court, and that case involved civil contempt for which the defendant actually was incarcerated for his failure to pay a debt. And this court in that case unanimously ruled that as a matter of due process in that case, the defendant should be advised that he can hire his private attorney. But there was no indication of the right to the assistance of counsel at the expense of the Commonwealth in that respect. And I also think that the factor that your question, Your Honor, focuses on now, the first factor, I think it should not be taken in isolation. It should be taken together with other relevant factors, including, like I said, the additional and alternative procedural safeguards, which I would submit amply ensure that the defendants have access to those proceedings equal with the victims, and they understand what the order says.
Counsel, may I ask you one question in terms of looking at the legislation overall? Why do you think the legislature did not include a provision for an attorney at this stage?
Because, Your Honor, that goes to the third factor in the attorney line of cases, the countervailing interest at stake. The providing for the attorney, and this is what I believe Justice Gans was concerned about in his concurrent opinion in the Grulon case, will create an immense asymmetry of representation, because if that is done, then the alleged victim who bears all the burden of proof is not represented by anyone during the
But
hearing.
isn't the solution to that is that they both get counsel, as the WBA contends?
Your Honor, I would believe that would incur significant expenses on behalf of the.
Aside from expense, and is there another issue here with regard to how long this process could end up taking? Is there an expediency issue that's involved?
Yes, Your Honor, and this is also another concern that the Turner Court expressed when they said that the introducing counsel into those proceedings can create delay and introduce a necessary degree of formality that that will make the proceeding less fair overall, especially for the victims in this case. That said, Your Honor, if this court finds, which, to be honest, I believe it should not, that there is the right to counsel for the defendant, then to avoid that asymmetry of representation, I think it would be fair also to afford the same right to counsel to the plaintiffs in the abuse prevention order proceedings. I see that my time is up. Unless the court has any further questions, I shall rest on my brief.
Okay, you didn't get a chance to respond to the question about the amicus brief that suggests that maybe another way to deal with this is use immunity.
Yes, Your Honor, I'm happy to do that now, although I would at this point ask the court for the relief under Rule 17B, Madam Chief Justice, if the court is amenable to that, if we could submit something in writing to the court, and if the court grants that relief, I would concede that it should be reciprocal for the defendant and the Commonwealth, of course.
Okay, why don't you do that? Why don't we have you submit something, and of course, the defendant can respond.
I appreciate that, Your Honor. Thank you
Okay,
very much.
thank you.